business perspective, that is better. The more you can go after to try to collect monies, the better it is for your clients. So you've got a lease violation, someone's holding over, what do? You go to the JP court, you file your eviction. A common problem that I see, and I think I've seen it with this management company, is that you're trying to save on fees. There are two people living in the property, especially if they're unrelated, roommates that have signed the lease, residents, and you go and you name only one of them, and so let's say it's Israel, Kirk go out and lease, and we default, so you go out and file a suit against Kirk, and you get a judgment against Kirk, and then all of a sudden the constable comes over to my place, and they try to remove my stuff, saying, no, can't do that, you don't have a judgment against me. I will sue you, constable, if you remove any of my items. And the constable doesn't know what is mine versus what is yours, do they? They don't. And if they remove mine, the constable is liable, and you guys are liable. You're liable for trespass, breach of contract, wrongful eviction, constructive eviction, you name it, you will have to pay. And the owner actually may have to pay and be liable, and you'll have a very unhappy owner. And more often than not, and even worse, you hire my services to handle the case up in, say, Dallas County, Collin County, wherever. We go, we get a judgment, attorney's fees, everything, and you may have to start over because the constable gives you a call and says, hey, I can't go and execute, or we can't do a writ of possession on this because you only got one of the parties. What about the rest of the parties?
What good or bad does it do us when I want eviction on grounds of unpaid rent? We want to evict John Walters and all occupants. Is that all occupants? Is that kind of will that encompass that? Or
that's what I'm getting at. And if you look at my Evicta guides, in the back of the Evicta guides, and you follow those, I developed this for years of folks goofing it up, and these are the recommendations of how to go about doing this. But an occupants have two categories, okay? They're either authorized occupants or they're unauthorized occupants. Well, what's an authorized occupant? It's an occupant that's stated under occupants as to who, typically children, okay? What's an unauthorized occupant? It's anyone that's not on that lease that's living in the property. Doesn't have your blessing or approval, so it's unauthorized, and you have both all the time. What's a resident? Well, the resident typically is the party stated under residence. And a resident is one that signs the lease. And in fact, if you only have one person that signs the lease, in my professional opinion, you have one resident. Even though you might actually designate 3 residents. If only one of them signs the lease, you really have one, because it's one person agreeing to be obligated. They're the ones who you go to, and they're the ones that have the authority to tell you they want to do this, they want to do that to the property. They're the ones you go to and sue if they don't pay the rents. You don't go to the occupant. I mean, you're not going to go to the unauthorized occupant and say, pay rent, are you?
So do you recommend that when we file for an eviction, we file on each occupant or each person who signed the lease?
Resident.
You must do that.
Resident.
To not do that is error and a problem. And a lot of folks get away with it and have done it for years and years. But that one time that it comes back to bite you, it'll be a very expensive process, and you will have a very unhappy owner. I've had it happen. I warned the client, and sure enough, it was a tenant from hell. And I later found out that the tenant does this. There are professional tenants out there. We see, in fact, we run into periodically that know how to manipulate the system, and then they try to appeal it on up. I mean, they go and try to appeal it on up to the Dallas Court of Appeals.
And they have attorneys that they work with to do suggestion of bankruptcy a number of times. I had one that did it 4 times.
Yeah, and the laws have been changed, and there's a presumption, you know, on the third time, there is no stay, and I think on the second time, there's an issue with the stay as well. And you can more quickly get something from the federal bankruptcy courts, because a lot of these judges will tell you that you need a stay lifted, even though sometimes you really don't need a stay lifted. They won't do anything. When they hear, a lot of these JPs, when they hear bankruptcy, can't do anything, can't do anything, go get an order. They don't want to do anything. And some of them, I think, are simply lazy, because let's say, for example, that somebody files bankruptcy, and they're in one place they go, and they move to your place, they give you a very large deposit, and they default. Well, that bankruptcy should not stop you guys from being able to go under a brand new lease after they have filed bankruptcy. It's not part of the bankruptcy estate, and you go after them. And that's also true after they have filed bankruptcy and have continued to pay you for some period of time as well. So, and especially if you have a lease renewal on a month-to-month basis after they have filed bankruptcy, they're still obligated as if they had not filed bankruptcy. Now, you can't get any of the monies before the bankruptcy date. You can't touch. After the bankruptcy, that's a different story. Late fees and things like that before, if they file a Chapter 13, that's going to be part of a plan that may get paid, you know, out over a period of up to 5 years. But you can't get a judgment for any of that or mess with them for the past damages.
With evictions, really quick, have you seen any problems with Section 8 of the lease that we use in TAR and applying all non-rent items first, and then leaving the rent short, $100 for late fees, $75 for utility charge or whatever, that's now rent, and then filing for eviction based on that shortage?
I don't have a problem with that. But let me tell you, the basic rules are that if you have a rent, you need a lawyer. You're required to have an attorney represent. If you're not the owner and you guys aren't the owners of the property, you need to be represented by an attorney for reasons other than the non-payment of rents. And I understand that a lot of folks will say, well, you know, let's just apply these fees and go ahead and kick him out as rents. But that can go back against you, because it depends on what you're applying as the rents, and that could be a dispute. Let's say that there are damages beyond normal wear and tear, or there's a problem, or there's an issue with a fire, for example, and who was responsible for the fire, and they're going to contend that they were not responsible, and all of a sudden you're accelerating their deal, and they're going to go in, they're going to bring someone in and say that we weren't even responsible for that, you should not have accelerated it, and then you have a problem. At that point, you should have contacted counsel to be represented, or the owner should have a lawyer representing them under those situations.
So if ever there's a question about the charge, but the vast majority of them are late fees, utility charge, where we get a bill, they were in the property, it was usage, so we know that it was them.
Right.
You know, something like that. Those are, you know, pretty much cut and dry. But you're saying anytime there's a question about the charge, to be careful with
the
that.
utility bills, at least under TAA, are a separate obligation that somebody has got to pay, and so it's the equivalent of paying rents or not paying rents.
Exactly.
I don't normally see an issue with that. If someone doesn't pay the utility bills, that you can go and you can handle it yourselves. And of course, if the case gets appealed to a county court, you need to early on contact counsel or contact our office, let us know. And let me talk about Hopper's affidavit, since we're talking about appeals at this point.